No one enters into a relationship expecting it to break down, but the reality is well over half of all marriages in Australia break down, and well over 2/3 of de facto relationships break down. Having a financial agreement ensures that you and your partner avoid the very expensive, very delayed, very emotionally draining process of property settlement litigation. People can spend $50,000 to $100,000 on property settlement litigation, and all of that can be avoided by entering into a financial agreement with your partner. Now, as I said, no one likes to talk about the breakdown of their relationship, but then no one likes to have a car accident, and yet we have car insurance. No one likes to get sick, but we have health insurance, and of course most of us should have wills, notwithstanding the unpalatable nature of death. The reality is a financial agreement is one type of insurance, a very important type of insurance that ensures that you don't have to pay a great deal of money, have long delays, and have expensive and emotionally draining litigation to sort out your property. Getting a financial agreement ensures that you and your partner have agreed to what might happen to your property in the unthinkable event that your relationship breaks down, and then you avoid all of the difficulty associated with property settlement litigation. A financial agreement can be entered into at any stage of a relationship, at the start of a de facto relationship, during that relationship, before two people get married, indeed during that marriage, even after separation or divorce. We recommend people consider entering into a financial agreement at the start of their de facto relationship. That might happen if a child is conceived or people decide to move in together. Two people can make provision and come to an agreement with respect to what might happen to their property should their relationship break down. They may even put that agreement down on paper and even sign it, but it will not be binding until certain provisions of the Family Law Act are met. Those provisions essentially require each party to receive independent legal advice before entering into the agreement, that the agreement is in writing and it contains certain provisions, and that the lawyers certify that they've provided the advice to their client. A financial agreement can contain certain terms which provide for how the parties maintain their financial arrangements during their relationship. It obviously can provide to what happens to the property after the relationship breaks down, and also can provide for the way in which the parties might maintain each other after the relationship has terminated. It is very difficult to give a precise amount about how a financial agreement might cost. Generally, the complexity of the terms might increase the cost to the parties. However, parties should be prepared to pay in excess of $3,000 to get the advice from both lawyers in order to draft a simple financial agreement. That is a small price to pay compared to the tens, sometimes hundreds of thousands of dollars that may be spent in litigation for property settlement in the courts.